Hey everyone, it's Rob Ryder. It is December 4th, 2013. Got so many things to talk about. They're not all related. Hard to decide what to talk about first. Everything from DBAs and assumed name certificates to determining your domicile, confessed judgments. What else is there? Extinguished debts, implied trust, secret trust, and special proceedings. So I had to pick something, so I'm going to start with special proceedings, and the rest will have to be on separate videos. So this one's going to be on special proceedings, and what do they really mean? Well, really what it equals is that's how you get a mandamus, a certiorari, a quo warranto, and other prerogative writs. And prerogative writs were writs of the king, right? Come from the king's bench. Original writs under the Great Seal from the Court of Chancery. So we're going to be talking about why this is, where you can find it, and see if we can get somebody to go use it and tell us, okay, I can get you 70% of the way there. We're going to have to get some people in the field to go and who have a problem to go to the next step. That's all we can do. And again, I'm Rob Ryder. My email address is courtofrecord@aol.com, and my phone number is 616-712-6179. And will you donate? My PayPal account is my daughter's name, Ashley Rytlewski, ASHLEYRYTLEWSKI @gmail.com. That is the PayPal account name. Or the mail is Robert Rytlewski, 10955 14 Mile Road, Rockford, Michigan. I didn't put the zip code on there. 49341. 49341. Can't pay my rent again. What, December, what did I say it was? December 4th? Yeah. I got to do better than this, or I'm going to have to go do something else. I know a lot of you probably say, well, that's what you should do. Well, I don't know. Right? I don't want to go back and play with the beast. I can go back and be a real evil son-of-a-bitch now. It's easier to protect yourself if you want to be evil. So, I don't want to be. So I'm going to find a way to make it work. And if you can help, I appreciate it. So, as great as special proceedings is, and I can't wait to talk about it, I have to talk about this other thing. This is just blows my mind, right? This has more to do with your domicile and where the republics are. So Thomas Jefferson had this idea about this thing called ward republics. And Jefferson considered the creation of a ward republic system of local government one of the two most important elements upon which the future of the republic depended, the other being the creation of a public education system. Jefferson devised a four-tiered system that would comprise national, state, county, and ward levels. Each county would be divided into a checker box wards of about 25 square miles, large enough to ensure an appropriate level of support for vital functions, yet small enough to allow for regular direct participation. Now, most of you saying, okay, he's talking about townships. Well, I don't know. Here townships are 6 by 6, 36 square miles, not 25. And for myself, I've determined it's not the township because I've gone down there and tried to make it my domicile and so forth, and they wouldn't let me do it. And I looked at the road and said, well, shit, they're not taking the oath prescribed in the Constitution. So it looks like it's what we have are survey townships, and a survey township isn't necessarily the same as an organized township or a civil township. They don't have to be the same. So the affairs of the larger sections of counties of states of the Union not admitting personal transactions by the people will be delegated to agents elected by themselves. Right? So there's certain things that we want to do because we can't do apparently we can't do personal transactions with the counties, the state, or the union. the federal government, we have to do it through some elected individuals. And they're not in the national, the state, or the county. So it's a local government. Who the hell are they? The representation will thus be substituted where personal action becomes impracticable. Interesting. So although his proposals were not generally adopted, we do see partial implementation of the idea in small townships, school districts, voting precincts, and neighborhood associations. Isn't that wonderful? Do you know that a school district is considered a local government? It is. This is great. This is Rose District, school district that she's in Illinois, District 303. So it says District 303 is governed by the Board of Education consisting of 7 elected members. The board's power and duties include the authority to adopt, enforce, monitor all policies for the governance of the district schools. Board of Education members are guardians of the public trust. I never heard that before. Anybody ever admit that they're the guardians of the public trust? You want to make somebody your trustee? Go to the Board of Education. They're guarding the public trust. As it turns out, when your child goes into school, you need to give the school a copy of the original birth certificate. So District 303, now it doesn't say the school district, it says District 303, so the territory of District 303 is governed by a Board of Education. Forget the school, because the great thing is, go look at the definition of school. School means leisure, has nothing to do with education. It's a leisure time, devoted to sports and activities. What's a municipality? This will be, because this is what feeds in. Because, all right, so we're trying to determine the local government entity. And it should be a municipality because in the law of domicile, you're supposed to domicile your natural and legal person in a municipality. Well, it's pretty all-encompassing. Counties, cities, villages, townships, local school districts, intermediate school districts, community college districts, libraries, other local and intergovernmental taxing units. All sorts of things can be a municipality. What municipality are you picking? So one last thing on Jefferson, and then we'll move on to summary proceedings, special proceedings. He wrote this in a letter. We should thus marshal our government into a general federal republic for all concerns foreign and federal, that of a state for what relates to our own citizens exclusively, the county republics. The county are republics. Look at that. For the duties and concerns of the county. And number 4, the ward republics. Another republic, another jurisdiction. Outside of the county, outside of the state, outside of the federal, another republic. The elemental republic. For the small and yet numerous and interesting concerns of the neighborhood and in the government, as well as in every other business of life. They're supposed to be involved in your business. It's where you do your business. It is by division and subdivision of duties alone that all matter, great and small, can be managed to perfection. And the whole is cemented by the giving to every citizen personally a part in the administration of the public affairs. Your local government is your school district. And I believe from the things we had done in the township a year and a half ago, where it said you go to the organized township and you become a registered elector and you appoint them your agents and attorney, that's exactly what you're going to do at the school district. Because that's the township they're talking about, not the survey township. Forget that. Right? A municipality township, known as the local school district. Wild stuff, man. Who would have thought? Who would have thunk it? Okay. It's interesting how people send me things or send me links to things as I'm going through, thinking about things. I got sent this thing here. that has to do with this idea of special proceedings. Jurisdiction as property in peer-to-peer government. Modern civics and political science is often taught an absurd dichotomy that the government is a monopoly over the use of force. That's what government is, a monopoly over the use of force. That's why you want to make sure you're in the right government, part of the right government. And that the absence of government is anarchy. Using this fallacious dialectic, many highly lawful societies, such as most medieval Europe, and in particular medieval and Renaissance England, were anarchies. Even the United States is really an anarchy. Jurisdictions are divided among federal, state, county, municipal, and other entities, including shopping malls, mass transit authorities, whose security guards can legally arrest probable criminals. Some states even still allow citizens' arrest, although it's not recommended that the people who don't understand the procedural distinctions between arrest and kidnapping try it. That's what we're going to teach the police. Government does not and should not come in the abstract forms taught by high school civics and political science, nor in the economical models of law that we talk about in law being enforced by the government. Hang on a minute here, I'll make this a little bit bigger. In medieval and Renaissance England, and many other later instances, English jurisdictions were property. Jurisdiction is property. The king had granted as property called a franchise much jurisdiction to lords and corporate bodies such as church organizations, municipalities, and colonies, but owned the residual jurisdiction of the realm, i.e. the jurisdiction not allowed or not owned by somebody else. This grant would take the form of a property deed called a charter. The franchise could also be owned by prescription, i.e. having exercised the jurisdiction since the English time out of mind year of prescriptive property rights, 1189 AD. If you're doing it in 1189 AD, it just automatically got pulled forward to say that that's what the common law is. Where franchise courts had exclusive jurisdiction, the king's courts were merely night watchmen, courts that ensured that the franchise courts stayed within their property boundaries, their jurisdiction of procedural bounds. Medieval and early English courts thus formed more of a peer-to-peer system than hierarchical current system, where higher courts generally view both procedure and substance of judgments in lower courts. Okay, and that's how it is now, right? That's really what we have is the franchise courts don't have exclusive jurisdiction anymore. Is it the King's Bench or the Court of Chancery? I can't remember now. Has concurrent jurisdiction in all cases. I think it's the Court of Chancery has concurrent jurisdiction in all cases, but it could be it's the King's Bench. I have to go back and see what Blackstone said. So like a merchant court could exercise jurisdiction over merchants doing business at a market fair, the court was appursuant to, and the law it exercised was merchant law. There you go. And that was by franchise. This only had to be consistent with royal law and keeping within its jurisdiction, procedurally as well as territorially. Substantively, such laws could and often did diverge sharply from royal substantive law. So the actual law that they used didn't have to be anything like what you would think the royal law is. So here we are reading statutes and codes. Maybe it's not what they're using. There were dozens of standard jurisdictions, dozens of standard jurisdictional franchises. For example, in Fang Thief enabled a franchise owner to hang any thief caught red-handed in the franchise territory, whereas out Fang Thief enabled the owner to chase the thief down outside the franchise territory, catch him red-handed, and then hang him. Gallows enabled owners to try and punish any capital crime, and there were a variety of jurisdictions corresponding to the several classes of lesser crimes. View of Franklin Pledge allowed the owner to control the local militia to enforce the law. The sheriff's pleas allowed owners to hear any case that would normally be heard in a county court. There were also franchises that allowed the collection of various tolls and taxes. A corporation was also a franchise, and corporations often held as appurtenance jurisdictional franchises. The City of London was and is a corporate franchise. In the counties Palatine, the entire government was privately held, and most of American colonies were corporate franchises that held practically all jurisdiction in their territory. Right? All the jurisdiction was held by private individuals. Sometimes subject to reservations, such as common law rights of English subjects and the right of the king to collect customs reserved in American charters. The colonies could, in turn, grant franchises to local lords, as with the court barons and court leet in early Maryland, and municipalities. In terms of protecting personal liberties, franchises in general and colonial corporations in particular ranged all over the map. Those where Englishmen themselves settled those where Englishmen themselves settled large numbers, such as American colonies, tended to be protective and even expansive of liberties, but many other English colonial corporations, from the East Indian Company to the Royal South African Company, could be authoritarian and brutal, especially to non-Englishmen. So, here's the kings of England giving away property in India or wherever the hell they said, okay, well, here you go. You can have South Africa, do as you please. Who are they to give South Africa to anybody? But, well, they did it all over. That's called imperialism. That's what they did. And if you were not an Englishman, but the law wasn't, because it was all private law, it wasn't really that going to work in your favor. Those medieval and Renaissance times, and to some extent well into the colonial period, the basic laws of English jurisdiction were property laws. The basic actions, kinds of lawsuits consisting of jurisdictional procedural of a court, were of those of title and trespass. Infringement of jurisdiction was a trespass. An abuse of a defendant by a court, violating common procedure law, could be a trespass. If any person, including a royal or franchise official, confiscated a person's goods, right, personal property, or imprisoned an individual, or administered some other coercive remedy, he could be sued for trespass. He then had to defend his use of force as a matter of legal authority, and that he had rights as a victim seeking remedy, or rights by owning a jurisdictional franchise, and that he exercised those rights within the personal, substantive, and procedural bounds of the procedure, or of the jurisdiction, of the charter. The king's courts could only reach inside exclusive franchise jurisdictions through the extraordinary or prerogative writs, which were writs of trespass or title. Thus, where franchise courts held the substantive jurisdiction, the king's courts generally could not review their proceedings for substantial error, only for trespass and jurisdictional and committing certain procedural defaults, such as depriving a defendant of the right to a jury trial. Indeed, many of the procedural rights specified in today's United States Constitution probably have their origin in the legal authority defense required of both franchise and royal courts to exercise coercive process without trespassing on the defendant. David Friedman had described the legal system in medieval Iceland. This was also a peer-to-peer justice system, albeit specialized, and some even more decentralized, and the personal jurisdiction was tied more to choice than to territory. All right, so here you go. How are you going to choose your personal jurisdiction? It's tied more to choice than to territory. In political science terms, medieval Iceland has been called an anarchy, but it is more realistic to describe it as a very peer-to-peer kind of government, where medieval England was partially peer-to-peer and partially hierarchical. And modern governments tend, on the Imperial Roman model, to be quite hierarchical. The Iceland system, also based on jurisdictional property. The Godord. However, the Godord was more a protected surface, champion, legal advocate, and executor of the law than a judge. The court of last resort, since Iceland had no king, was the democratic all-thing. But it was more than a night watchman's court, as it reviewed substance as well as procedural dispute settlements arbitrated in the Godord. In our modern system of arbitration based on choice of form, clauses, and contracts, personal jurisdiction is based even more on choice. But it is embedded within our Imperial Roman system, hierarchical and territorial court system. Alright, because we got both. We got the Roman hierarchical and the territorial court system, I guess, and the reviews. I thought we had English law, right? How come I'm talking about all this Roman shit? Where'd that come from? We must have been sleeping and they changed the laws. Okay, so I didn't read all this, but at the same time as the American Revolution eliminated most titles, it eliminated most franchises, except for certain rigid forms such as municipal corporations. Those franchises still exist. Well, it says which are no longer considered an instance of a franchise, except for certain forms of municipal corporations which are no longer considered an instance of a franchise. Okay. Corporate colonies and county palatines were converted into states. Actually, this process started well before the American Revolution, which was more of a climax to the process. So anyways, way back in the day, right, if a royal or a franchise officer did you wrong, you would go get an extraordinary writ for trespass. Well, that sounds like some kind of special proceeding. What can we do today? Well, in New York, they have a thing called Article 78. And Article 78 proceeding is named after Article 78 in the New York Civil Practice Laws and Rules. Relief that was previously obtained by writs of certiorari to review, mandamus, or prohibition can be obtained in a proceeding under this article. Well, those are the prerogative writs. However, a proceeding under this article shall not be used to challenge or a determination that is not final or one that is made in a civil action or criminal matter unless it is an order summarily punishing a contempt committed in the presence of the court. All right, we're gonna has to be about contempt of court. Fraud is contempt of court. Charging you with a crime without having a sworn complaint is contempt of court. Well, what do you do when you have those problems? You have to, in New York, they call it Article 78. In Michigan, it's just called a special proceeding. A proceeding under this article, being a special proceeding, can be brought only in the Supreme Court of the county. I think in New York, where we have circuit courts, they have Supreme Courts. So each county has a circuit court here in Michigan. But they actually call them the Supreme Court of the county in New York. That's very interesting. Well, New York, if a county is a republic, because that's what Thomas Jefferson was trying to set it up as that the county is actually a republic. Doesn't answer to anybody. The only way it's going to answer to anybody is through concurrent jurisdiction to the King's Bench. So how do you know what you can do? Well, the following are questions that can be raised in a proceeding under this article. Whether the body or officer failed to perform a duty enjoined upon it by law. Whether the body or officer is proceeding, or is about to proceed without or in excess of jurisdiction. Okay, so for instance, does that police officer, did he ever take the proper oath? By what authority does he bring this charge? Is he within his jurisdiction to charge me with anything? All right? Now, right now, they treat us like we're. This is what the county auditor told Roe why Roe had to pay county taxes, because Roe was a citizen of the county. Not a citizen of the state, not a citizen of the United States, a citizen of the county. Right? Now, they don't make mistakes. He said that on purpose. I mean, he told her, you're a citizen of the county. Well, how would you be a citizen of the county and not a citizen of the state? You're just a resident of the state. I'm guessing. Well, that would be if the county is a republic. That really doesn't have a damn thing to do with the state. Whether a determination was made in violation of a lawful procedure, like there was no sworn complaint, was affected by an error of law, like there was no sworn complaint, or was arbitrary or capricious, like there was no sworn complaint, or an abuse of discretion, like there was no sworn complaint, including abuse of discretion as to the measure or mode of penalty or discipline imposed, or whether a determination was made as a result of a hearing held and at which the evidence was taken pursuant to the direction by law, is on the entire record supported by substantial evidence. Whether a determination made as a result of a hearing held and at which evidence was taken pursuant to direction by law is on the entire record supported by substantive evidence. All right, I guess if you put evidence in, they didn't pay any attention to it. You can say, look, I put evidence in, they didn't pay any attention to my evidence. Right? I said that I don't have a contract with the plaintiff. So how can he be taking my property? I've said that there's no sworn complaint. Anytime you're in court, look, I don't care if it's civil or criminal. If you're in court, it's because you committed a crime. It's just some crimes are against a person, other ones are against the state. The ones against the state are criminal. Right? The ones against a person or property are civil. But, a trespass is a crime. Right? A tort's a crime, and that's the kind of stuff that's in civil. So, the expression body or officer includes every court, tribunal, board, corporation, officer, or other person or aggregate of person whose actions may be affected by a proceeding under this article. That's interesting. Body or officer includes every court, tribunal, board, corporation, officer, or other person. So this isn't necessarily just state people. And let's go back and look at this first one. Whether the body, corporation, failed to perform a duty enjoined upon it by law. If you go look at your title insurance that you paid for on your title insurance policy, it says on there they have a duty to defend your title in fee simple. And they've never done it. So, right? We want to call them in and get a mandamus saying, do your job. Whenever necessary to accomplish substantial justice, a proceeding under this article may be maintained against an officer exercising judicial or quasi-judicial functions, so it can be used against a judge or a member of a body whose term of office has expired, or a member of a body whose term of office has expired. So he's sitting there without it. He doesn't have his term of office is done. The office is vacated. But he's still sitting there, like he's holding a position. Any party may join the successor of such officer or a member of a body or other persons having custody of the record or proceedings under the review. On the motion of any party or on its own initiative, the court may stay further proceedings or the enforcement of any determination under review upon terms including notice, security, payments of cost. Okay, so these are all the things that can be brought up in a special proceeding. Now, what I'm reading here are just the New York Civil Code, right? 78, Chapter 78, whatever it's called. Relief previously obtained by writs of certiorari to review, mandamus, or prohibition shall be maintained in a proceeding under this article. Okay. That's just really going over what I just had talked about. What's the procedure? Special proceeding. Where the procedure is brought, a proceeding under this article shall be brought in the Supreme Court in the county specified in the subdivision of Section 506, except as that subdivision otherwise provides. That's interesting. I don't know what that means, right? But I'll be looking at 506 to see what that means. The Supreme Court in the county specified in subdivision B of Section 506. I'm going to tell you what the Supreme Court of the county is. As we're going to see in a minute, when you start this case, and this is where everybody makes a mistake that I can see, you start with the county clerk before you go to the court. You start the case with the clerk, county clerk. Time of service, pleadings, answering affidavits, objections and point of law, hearing and determination, transfer to the appellate division. Where the substantive evidence issue specified in question 4 of 7803 is not raised, the court in which the proceeding is commenced shall itself dispose of the issue in the proceeding. Where such issue is raised, the court shall first dispose of such other objections as could terminate the proceeding, including but not limited to lack of jurisdiction, statute of limitations, res judica, others, yada yada yada. Court shall make an order directing that it shall be transferred for disposition to a term of the appellate division held within the judicial department embracing the county which proceeding was commenced. So if we go to 7803, question 4 is 7803. Where's 7803? 7802. I don't see any questions. Oh well. I have to read it closer some other time. Okay, so that kind of tells you what this is, but how does it work? Well, we're not ready for him yet. So, those who have been watching my videos for quite some time have seen this before. This is from a self-help center at one of the courts in New York, and explains how you put this paperwork in for a special proceeding. So, if you're not in New York, and it's not going to be called Rule 78 hearing, it's going to be called a special proceeding or something else. You're going to have to figure out what you call it there, and you're going to have to go down and ask them if they have any paperwork, anything that could help you at the self-help center to do a special proceeding, and get yourself some copies. The other thing is, let's say you're in a traffic case, right? Tell the judge you want him to appoint you an attorney and have him do it. Right, the thing is, we need to tell them what to do instead of letting them decide for us, because they're just practicing law. They don't know how to fucking do law. They're practicing. It's a practicing attorney. It's practice. Playtime. All right, well, freaking PTO, man. Playtime's over. So you just tell them, look, I want you to put in a special proceeding to get a writ of mandamus to make him do whatever he needs to do, or a writ of quo warranto, or whatever it ends up being. Okay, special proceedings can be used only where it is specifically authorized by statute. There are a number of these, but generally they relate to challenging the action or determination of a government officer or agency. See Article 78, which we looked at. Also, landlord-tenant relations can also be determined in a special proceeding. In some instances, otherwise, special proceedings usually cannot be brought against private parties. I really believe this court we're going to is the lowercase probate court. In order to commence, and if it was the lowercase probate court, it would be the court of chancery, because it would be the ordinary sitting there. In order to commence the kind of lawsuit known as a special proceeding, and the other reason is the King's Bench is a court of common law, and in courts of common law, courts of common law can only give money damages. That's all they can give. Now, that's the way it was back in the day, and now they tweaked the laws a little bit. But it's the Court of Chancery that has all these things other than a money damage. In order to commence the kind of lawsuit known as a special proceeding, a person must prepare a document called a petition. And you're going to be called a petitioner. It doesn't say it here, but it said it on something else. 8.5 by 11. It tells you to go read this rule here and make sure you know what you're doing. Top left-hand corner, petition should designate the court of the county of the proceeding. Next comes the caption. Okay, I don't want to spend too much time on reading about petitions, but unfortunately this doesn't have Appendix A attached to it. What I really want to get down to is that this is just doing a petition. What do you do after you get the petition done? How to set the wheels in motion. New York law requires that papers commencing a special proceeding must be filed with the county clerk, and that an identifying number and index number be obtained. You must go to the county clerk and get an index number. The petitioner should go to the county clerk's office. The petitioner will have to fill out an index number cover sheet form. So you're going to ask the county clerk for the index number cover sheet form and purchase the index number from the cashier for $210. However, if you can't afford the $210, this is where you do the poor man stuff. The petitioner must write in the index number assigned by the county clerk in the index number space to the right of the caption on each of the documents prepared by the petitioner. A copy of all these documents must be filed with the county clerk. We're not even to the court yet, right? We're into the county clerk's office, who will open a court file for the case. I wonder if it's a different freaking court than we normally go to. The clerk will stamp the petitioner's copies to show that the paper is filed, and it will issue a receipt for the purchase of the index number. You're going to get a receipt for the purchase of the index number. The petitioner needs to file with the clerk, county clerk, the following initial legal papers. Tell you what it is. In order to bring the proceeding before a justice, the proper title, right? So now you're going to get an index number. You're going to file with the clerk, because she's going to open a court file, all the papers. If you want to know where all the papers are to start a court case that you're in now, see, when Rich in Alpena had to hire an attorney because we had tried some things that wasn't working, he didn't want to go any further, he hired an attorney. What'd the guy do? He put in one piece of paper, actually two pieces of paper, one to the county clerk and one to the court. How many people are going to the county clerk with anything to do with their court case? Raise your hands. Look around. I bet you don't see anybody else's hand up. In order to bring the proceeding before a justice, which is the proper title of a judge assigned to the Supreme Court, is justice. Of this court, the petitioner needs to request that the case be placed before the justice on the calendar. This is done either of two ways: by serving and filing a notice of petition, or proceeding by order to show cause. A notice of petition is a document directed to the respondent that advises the respondents of where and when the petition is to be submitted to a justice and identifies all the papers upon which the special proceeding is based. An example of notion. Again, we don't have an Appendix A. They don't have any appendixes attached. That's one way. You should be using an order to show cause, because the other name for that is called a subpoena. Also serves to give notice to all parties. but the form of the document is different. Yeah, it's actually a court order. It is in reality a court order and must be presented to and signed by the justice of the court at the outset of the process in the court. Right? So you would have to go to him with your, it sounds like you go to the justice at the same time and have him sign your subpoena. That'll freak him out. They don't do that very often. The court's under no obligation to sign the order to show cause or grant temporary relief, and may instead tell you to make your application by means of a notice of petition. Because you can be asking this guy for a stay in whatever the proceeding is that you're having a problem with. Right? So he can give you a stay. Filing in court, moving by order to show cause. When moving by order to show cause, petitioner should prepare the petition. One copy should be filed with the county clerk, as explained above. At this point, a filing with the county clerk has been made, but a filing with the court has not yet occurred. Oh, we got more to do. The petitioner should next proceed to the Supreme and County Court Clerk's Office. They got another office. It's called the Supreme and County Clerk's Office. County Court Clerk's Office. They got a county court. Says right there. Right? Been looking for the county courts? There they are. Got to give them another $95. Make it out to the office. Oh, to the office of the county clerk. Not to the county clerk, to the office. You just found the office of the county clerk is the same as the Supreme and County Court Clerk's Office. I'm guessing. Have to ask him that question. Because one of the things about doing a DBA or assumed name certificate in Michigan is you're supposed to take it to the office of the county clerk, which is different than the county clerk. And if this is saying that next you proceed to the Supreme and County Court Clerk's Office, and you give them some stuff, and you write them a check, and the check's going to say Office of the County Clerk, and you're still standing in the same office, I guess you're in the Office of the County Clerk, also known as the Supreme and County Court Clerk's Office. Outstanding. The clerk's office will then review the petitioner's papers, make sure that they are in proper form, and if so, will assign the case to a justice on a random basis. Oh, okay. You got to do some more. So the papers will then be delivered to the assigned justice for immediate review, and if found acceptable, signed by him and given to you so you can copy them and return the originals to the county clerk's office. Now you're going to take it to the court clerk's office. Originals to the court clerk's office, not the. So which court clerk? This one. Supreme and County Court Clerk's Office. The place where he wrote the check for $95. When the order has been signed, the petitioner must conform a copy, that is, reproduce a copy of the papers with each and every marking made thereon by the justice. Now this you would have to get some help on. I don't know what this means exactly, right? You're going to conform a copy, reproduce on a copy of the papers with each and every marking made thereon by the justice. This copy must then be photocopied and served upon the attorney. So you need to conform one and then make a photocopy of it. That's what I don't understand, right? So if you're in New York, you're going to have to go find out. Call me and tell me what the answer is. Service. Other parties do not submit opposing papers. Do not appear. Yada, yada, yada. Okay. Anyways, here's an idea. So, County Clerk of New York County, just to see what one does, right? Welcome to the County Clerk's portion of this website. The County Clerk of the County of New York serves several functions. First, the County Clerk is the clerk of the Supreme Court, Civil Branch, New York County. In this role, I'm responsible for creating and maintaining custody of cases, files, for lawsuits commencing in this court. Just told you. As the county clerk, he's responsible for creating and maintaining custody of the cases, files, lawsuits commenced in the courts. Maintenance of minutes for each case in which all files of the case are recorded, and the entry into the minutes or orders, judgments issued by the court. Under certain circumstances, the clerk is authorized to sign and enter judgments. Huh. All right. So, see here in Michigan, we got a county court. We have a county clerk who is normally also the clerk of the circuit court for the county of. Same person wearing two hats. Well, they're wearing multiple hats. Who knows how many hats they got on? They like their hats. What else we got? What else? Okay. Now in Michigan, all right, we got a whole chapter, subchapter 3, general provisions. This is special proceedings and actions. And all right, there you go. 3.3, extraordinary writs. There's a way to do it. It says right there, that's the court rules. It isn't necessarily the procedure, but it is the court rules. Because I don't think in here it talks about going to the county clerk. So, you know, it's hard to say what has to be done and how it's done. It's just, we have a thing called special proceedings, and you can get superintending control. In other words, you can get him to take over the case, a habeas corpus, a mandamus, or quo warranto. By what authority? Command him to do or not do something with a mandamus. Ask him by what authority they bring these charges with a quo warranto. Produce the body with a habeas corpus. Take over the case and, you know, take it from the lower court and handle it. So I think that's the problem with, you know, people have done habeas corpus and they don't seem to work. But if you have to take it to the county clerk first and you haven't done that, and that's step one, it doesn't matter what you do afterwards. If you can't follow, you know, procedure, they always tell us not following procedure. What do you mean? Oh, I got to take it to the county clerk. They got to open up a file. Go figure. So I'm going to send these things along, but all this stuff is online, right? All I did is I went and I looked up either special proceeding or whatever that Title 78 was. They call it New York, because these are all based in New York. Okay, so the person bringing the case is called a petitioner. You're not called a plaintiff. When you're called a plaintiff. And a petitioner, again, well, first of all, petitioner is petitioner or complainant, are the names of people in Court of Chancery. You got petitioner and complainant in a Court of Chancery. You got a petitioner in a court of law, or no, a plaintiff in a court of law. And according to Blackstone, that a plaint is when a case is worth less than 40 shillings, less than $20. Generally, the petitioner must commence a special proceeding against a public body or officer in any county within the judicial district where the respondent made the determination complained of or refused to perform the duty allegedly violated. You got to file with the county clerk's office. Only a poor person, as defined by law, may be exempted from obligation to pay these fees. Right? Because you got the $210 and the $95. It looks pretty expensive. $300 to do this. Put in the poor man's affidavit, the pauper's affidavit, whatever they call it. Where a special proceeding challenges the decision of a government agency in regards to some claimed right of the petitioner, the petition should specifically state in detail why the petitioner contends that the agency was wrong and must be annulled. This is going to end up where we go to get our estates back. This court right here with a special proceeding. If we have to do that. It could be that we just need to go to the local government, i.e. school board, and register as an elector there, and appoint them our agents and attorney and tell them to go get our property. Generally speaking, a petitioner may only obtain relief in this court in the form of a review and, if successful, reversal of a final agency action. At this point, you have filed your papers with the county clerk's office, but filing with the court has not yet occurred. Right? Go to the Supreme Court clerk's office. Things we've already read, it's written differently. This is a little bit easier to read, maybe. Got to conform that copy. Okay. And then a jailhouse lawyer's manual. Right? This is specifically geared towards using this Article 78. And let's remember, we're just talking about a special proceeding for somebody who's in jail. And, somebody should follow it really, really close. Maybe you'll get somebody out of jail. It talks about what an Article 78 proceeding is. Who hears Article 78 proceedings? Article 78 petitions are heard by New York Supreme Courts, which are the trial courts in New York. Okay, well in Michigan, it's the circuit courts of the trial courts. However, they say that probate courts are trial courts. So, I just want to make sure that in case you're watching this video and you don't get these handouts I put, all this stuff you can find online yourself. It's very simple, right? Put in a jailhouse lawyer's manual into Google and do some searching. It's from the Columbia Human Rights Law Review, 9th edition, 2011. They may have a new one out. What can you ask the court to do in an Article 78 proceeding? Order the state official or agency to perform a duty that it is required by law. Order the state official or agency not to act beyond the authority or violate the law. Like, where's the sworn complaint? Overrule a decision made by an officer or agency, like they charged you anyways without a sworn complaint, or order it to reconsider the decision because the decision was obviously incorrect or unreasonable because there was no sworn complaint. It was based on an error of law. Well, there was no sworn complaint. It was based upon insufficient evidence, like there was no sworn complaint. Well, basically this just says the same thing again. But the interesting thing about this, the reason I have this one is, because if you're not in jail, you say, well, it doesn't apply. Well, yeah, it will. But in here, they have, I don't know where it starts. A little higher. Examples of the forms to use. A1, order to show cause. Well, order to show cause, that's the same as a subpoena. If they put their seal on this, it's an original writ under the Great Seal from the Court of Chancery, and to defy the Court of Chancery shall rain the thunderous wrath of the Vatican upon you. Affidavit in support of an order to show cause. That's what a chancellor of a chancery court in Tennessee said back in 1907 or 1917, whenever he wrote the book. To defy the Court of Chancery shall rain the thunderous wrath of the Vatican upon you. Go figure, and you'll never know it had happened. And what you're doing is you're taking in to get an order to show cause, which is the same as a subpoena, which is an original writ under the Great Seal from the Court of Chancery. It was developed by the Court of Chancery. Affidavit in support to get your show cause, a notice of petition in case you're going to do notice of petition, Article 78 petition, gives you an idea what your petition needs to say, verification of petition, right? Now you're going to swear to your petition. Request for judicial intervention, in other words, you need to have a stay or whatever. Application for an index number. Well, you're going to put your index number there, right? You got to ask for this. Application for an index number. Somebody should go to their county court, should go to their county clerk tomorrow and say, I want an application for an index number, and just get the paper. Right? If you got a car, can get down to your county clerk, go asking for an application for an index number. I don't have a car I can put on the road. I can't pay my rent. Remember? If you can help me out, I really appreciate it. Affidavit in support of request for reduction, waiver of fees. There you go, man. That's the poor man's. Okay, he's a petitioner. I currently receive income, right? Well, first of all, you don't get any income whatsoever, right? I currently receive income. I don't get any income. I own the following valuable property, other than miscellaneous personal property. Right? Well, miscellaneous personal property is personal property. Everything is personal property. So you don't have any valuable property. It's all personal property. I have no savings, property, assets, or income other than set forth herein. Again, you don't have income, right? You work for a wage. A man's labor is worth his hire. Income is when you make interest on money for doing nothing to get it. Again, in IRS Manual 6209, 2013 version, Section 2, it'll list all the different forms used by the IRS. And I have all these different columns going down with some attributes about those forms. One of them is what tax class the form is used for. And when you look at all the forms that you would normally use, like W-2, W-4, 1099, things like that, they're all Class 5 gift and estate. It's not income. It'll list the ones that are income, but the ones you use aren't income. And Class 5 gift and estate has like a, I don't know, $5 million exemption or something like that for you to pay tax. So, right, you don't have any income. You have gift and estate. The problem is somebody else is keeping you from your estate, and that's my big thing, is I want my frickin' estate. But if you got a court case, you may want to deal with this stuff. So that's a good little manual, right? I mean, I haven't taken the time to read it. I don't know that I'm going to. I'm just pointing this out for those who have a problem. Maybe you can take care of it. My problem is I can't pay my rent. So will you donate? The PayPal account is ashleyritluski@gmail.com. And I am Robert Ritluski, 10955, 14 Mile Road, Rockford, Michigan, 49341. Until I figure out what my local governmental agency is and go down there and become a registered elector. Then we'll see what my address is. Appointed my agent and attorney. We're going there next. Next one will be about Jefferson's Ward Republic and all the other things that it has to do with that. So, anyways, special proceedings are how you get these prerogative writs to take care of the problem. You don't go into court. You don't go into their court and fight their battle the way they want you to fight it. You go into the county clerk and say, I want a frickin' writ of ceratoria. I want a writ of mandamus. Hell, I don't even know what I want. I'm just going to put my complaint in and you tell me what I get. All right? I'm going to complain that I don't have a... When you look at the plaintiff on a foreclosure, for instance, and you look at that name, take the name exactly as it shows as the plaintiff. Go try to find a certificate of existence, certificate of good standing, whatever, any place in the world. You're not going to find it. It doesn't exist. It's a fictitious entity. So fictitious, it's just It's just markings, scribbles on paper. They don't exist. Well, it's contempt of court to sue in the name of a fictitious entity. That's your complaint. So by what authority are they there trying to take your property? Pretty simple. We'll find out. I'm sorry for the crunching. I'm eating a couple of throat lozenges. Okay. But remember this, that the Board of Education members are the guardians of the public trust. Board of Education members are guardians of the public trust. Go find me anything else that says that somebody actually admits to being the guardian of the public trust. What's a guardian? Well, that would be the same as a trustee. Appoint them. That's what we're going to do. You're going to go appoint them, your agents, your trustee. That's great stuff. Can't wait to get to that one. I got to study a little bit more because lots of shit to cover. But this one's out of the way. Y'all have a great night. See ya.